Tonight on Canton Confidential, emotions running high in the courtroom.
Just like a lot of harassment.
As new questions emerge about an early morning detour.
The last entry is that you completed a 12-mile drive on January 29th of 2022 at 1:32 in the morning. And
today, we heard from those seen outside 34 Fairview.
I've noticed a male and a female in the car.
And the first expert witness to take the stand.
There was absolutely no canine DNA.
We're breaking down the day's big moments right now on Canton Confidential, the Karen Reed murder trial.
A full day of testimony in Denham, and we saw some emotional moments. We're going to unpack all of it. Good evening. I'm Glenn Jones.
I'm J.C. Monahan. Today, the prosecution called 7 witnesses to the stand, including the first expert we've seen testify in the case. It was also the first time we heard from people outside the home at 34 Fairview Road. They were there just hours before Boston police officer John O'Keefe was found unresponsive on the front lawn. The day ended with Colin Albert.
And if you've been following the trial, Colin Albert is a name we've heard a few times. He's the son of Chris and Julie Albert. He lived just a few doors down from Officer John O'Keefe for most of his life. Colin is also the nephew of Brian and Nicole Albert, who owned that home at Fairview Road.
All right, joining us live now to break down today's important moments in court is our Kirsten Glavin. Kirsten.
Well, that's right. Colin Albert is one of the people that Reed's defense team has suggested is lying about the time he left the home on Fairview Road that night with Allison McCabe. Now their text messages and phone data are in the spotlight.
So this is the evidence that we received.
For the first time, forensics introduced to the Karen Reed murder trial.
And that shows the 2 swabs that were contained inside that packaging. We did receive a piece of paper that with the submission saying it was taken from a shirt.
A forensic scientist from UC Davis testing these swabs, looking for dog DNA, to which she says there was none. Reed's defense team has alluded to injuries on John O'Keefe's body coming from the Alberts' dog Chloe, a German Shepherd at their home on Fairview Road.
There was absolutely no canine DNA.
Attorney Alan Jackson pressing that while no dog DNA was found, tests came back saying they could have also been inhibited or degraded. But there was DNA from another animal.
You were able to detect the presence of pig DNA, right?
Correct.
The defense pointing to pig often found in dog treats.
There are dog treats that are pig ears, literally.
Objection.
Allow it.
All right.
I believe so.
3 other witnesses taking the stand describing pulling up to the Albert home the night before O'Keefe died, seeing Reed's SUV pull up around the same time.
I've noticed a male and a female in the car.
The group offering to give a ride home to a passenger's sister, but says she came out and declined. Within 5 minutes, they left, saying they no longer saw the male in the SUV.
But you did look inside that SUV.
As I passed by, yes.
And you saw one person.
That's all I saw at the time, yes.
Female with long hair, is that
correct?
Right?
so you didn't see anybody in the front passenger seat?
No, I didn't look.
Next up, Allie McCabe, who gave a ride home to Colin Albert, a nephew of the homeowners.
Colin wasn't at the house, so.
But the defense referencing an app called Life 360, which was used by McCabe and her family to track each other's phones. Reed's attorneys claiming the data shows them taking an hour-and-a-half detour and at one point stopping at Canton High School.
The last entry is that you completed a 12-mile drive on January 29th of 2022 at 1:32 in the morning and 23 seconds. And that's the end of the activity. Do you agree with me that that's when you finally stopped that night?
I don't recall.
Emotions running high, recalling harassment by those who don't believe her.
People emailing my school.
Just like a lot of harassment.
Colin Albert later reading text messages between them that night.
And then at 12:10 a.m., Allie wrote here. And at 12:10 a.m., I wrote back, okay.
Testifying, they went straight home.
She drove me right home.
Outside of court, the defense saying data doesn't lie.
The way Life 360 works is there are bubbles for areas. And it can say you arrived at the high school when you're actually driving through the bubble. So, I think there are explanations that haven't been given yet. And I think, there are questions about whether they went right home or not.
Now, Mr. Yannetti hinted outside of court that they do have an alternate theory as to where Allison McCabe and Colin Albert went that night and why. They said they'll get to that later in this trial. Meanwhile, the prosecution has continued to say that this is all a distraction and that Karen Reed is responsible. Reporting live in Dedham, I'm Kirsten Glavin. I'll send it back to you guys in the studio.
Okay, Kirsten, thank you for wrapping up the day's testimony. We're going to dive a little deeper now with our legal expert, Michael Coyne. So I want to ask you about that Allie McCabe testimony about the cell phone data. She testified that she picked up Colin and then dropped him off and then went straight home. In cross, we know that from this Life 360 app, apparently it shows otherwise. Let's play a moment for the audience so then we can talk about it on the other side.
At 12:26 a.m. on January 29th, you left home again, right?
Objection, Your Honor.
Did you leave home?
I don't know. I don't remember.
Okay.
All right. And at 12:26 a.m. and 12 seconds, you arrived at the Canton High School, correct?
No.
On January 29th of 2022, at 12:26 and 55 seconds, you completed a 1-mile drive where your top speed was 43 miles per hour, right?
I don't believe so.
What's your legal analysis of how she was challenged and how she responded?
I thought she responded reasonably, consistent with her story. The question is the science behind the application valid or not? Just asking the question, as the judge will instruct the jury at various times, that's not evidence, the questions we as lawyers ask. It's the answers that are important. So at some point, if in fact that data is true and the application is valid, they're going to have to show that she did much more than just simply go home that night. And that's the real question that's still on the table. It does seem like everything else in this case, it raises more questions than answers, but there is a legitimate question as to whether the application properly recorded what she did that night or whether her testimony is truthful.
We heard one witness today mention that they were interviewed, or said, oh, you mean the interview with the feds? That is something we hadn't heard. It wasn't, I believe, supposed to be allowed into the trial. But what did it mean to say the word feds?
Well, there was a grand jury investigation, the federal investigation into this matter with respect to the conduct or misconduct of some of the law enforcement personnel and the DA's office in Norfolk County. And so the question is that you didn't want the jury to think that there's something nefarious going on here, and that was what the judge's ruling was earlier. But if the door is open, now you have to have some further explanation of it, and that's what happened today.
So, but nothing really was said after you said the word feds. Nobody objected or anything. So now what?
No, but it raises questions in the jury's mind. Well, what is this parallel investigation? Why did it happen? Is there something going on with the respect to the prosecution of this case that they're going to start to question and worry about? And you did see a couple of other references to, oh, I testified in May of 2023. Yes. And so they're now going to wonder what else is going on here that they're not being told. And there's probably a lot of those questions in their mind already as well.
Michael, thank you. Don't go anywhere. Michael's going to stick around to talk about today's expert witness. But before that, we want to take a moment to reflect on Officer John O'Keefe.
It's very easy to get caught up in the speculation surrounding his death. But at the end of the day, a man tragically lost his life, and the O'Keefe family lost a son, a brother, and an uncle. His niece and nephew lost their father figure. At the end of the day, the focus is singular: seeking justice for John O'Keefe. We'll be right back.
We're back now with our courtroom insider, Sue O'Connell. All right, Sue, 3 people who arrived in the same car that night, each separately testified today. And you made a comment that their testimony was different from other people who were at the house that night.
Yeah, Ricky, Ryan, and Heather had some of the most authentic testimony that I think we've heard so far. And that isn't saying that other people weren't authentic. These folks weren't necessarily coached the way that a lot of witnesses are coached, and they're supposed to be coached. It's not an insult here by any means. But they had 3 stories of arriving at Fairview, and each of their stories were different and had some inconsistencies in them that neither the defense or the prosecution really pushed back on, because directionally they were correct, right? Where Heather sat, if she sat in the front seat or the back seat. When Julie, the sister, came out to talk to her brother, did she talk through the window or did they open the door and talk? How far was the car that was Karen Reed's car that was there away from them? Was it a car length away, or was it 2 or 3 feet away?
Because all three of them said they saw a black SUV up front at the time they pulled in the driveway, and then minutes later they pulled out and left.
Right. So when they said things like, I don't remember, it was because they actually didn't remember. Right. And that this was sort of a holistic way that if I asked either one of you about an event that happened 2 years ago that, the holiday party, for example, would you be able to tell me the exact same story? Probably not. So there was a part of this that had a real authenticity to it. Now, these were prosecution witnesses, and to your point, they were able to place Karen's car there and Karen there, we think. So that's what the prosecution accomplished. Plus, we didn't get any testimony that they saw John O'Keefe go in the house.
One of the things your response there highlights is that it is difficult to get an accurate recollection from everybody on what happened that night. Interestingly, an app can do that.
Yeah.
It does not change its story over the course of time. When Allie was confronted with that information on the stand today, it felt very surprising as I watched at home. How did it land in the courtroom?
Yeah, it felt very surprising as well. This Life 360 app, she seemed surprised that they had the data. I talked to some people after, and it seems that maybe the prosecution didn't prep her for this. Maybe the prosecution didn't understand that they had this data. Lots and lots of pages that need to be looked at. The budget for a prosecutor's office is not the same as the budget for this defense team. So I think she was caught flat-footed there. We'll have to see what happens. As Michael said, if the science holds up, what happens when we get into technology? Either she was caught flat-footed or the defense was wrong. We'll find out.
Interesting. I have it on my phone. My daughters have it. But yes, now I want to know how accurate is it.
Okay. So thank you.
You're welcome.
We mentioned it before. A scientific expert testified today, a first so far in this trial.
So when we come back, a look at the DNA evidence at the center of today's questioning.
The Commonwealth put an expert witness on the stand today, so we have to talk about that. You're looking at Terry Kuhn, a forensic scientist from the University of California, who talked about DNA testing on John O'Keefe's body. Welcome back to Canton Confidential. We also welcome back Michael Coyne and Sue O'Connell. Both of you have been among the commentators who have said, get me to the forensic evidence. Let's get on with it. So we got our first sort of taste of that today. So maybe, Sue, you can explain to us first, what do you think the prosecution's objectives were with this witness?
Well, the prosecution with some of these, she was an out-of-order witness, which is important to note. The judge gave a notice telling the jury that sometimes you have to have a witness not in the storyline of the narrative that you want to have. So she was actually up to talk about disqualifying the idea that Chloe the dog bit John O'Keefe. The jurors have not heard that information yet. They might have, be able to figure it out because we're talking about Chloe a lot. We're talking about Chloe's behavior. But the jury did not know really why she was up there. But she did get up and she did disqualify that there was no canine DNA detected, right? And of course, as we all know from various tests we've taken over the years, especially COVID tests, sometimes you get false positives, sometimes you get regular positives. But she was pretty steadfast that she didn't think there was any dog DNA. Unfortunately for the prosecution, the defense just kind of then took her expertise and her exceptional laboratory skills and keeping the evidence chain as pristine as possible and tried to use that as an impeachment of the Canton police and their Solo cups. I saw the Solo cup, red Solo cup reference coming, the cups they used to collect the blood. And there was one juror who I've been watching, and when Alan Jackson mentioned the Solo cups, like, you wouldn't use Solo cups to take, she actually laughed like she thought that was coming. Yeah. So it was just one of these awkward days, but I don't know that we learned a heck of a lot.
No, in other words, the expert did your job, but they were criticizing, but the information that they gave you, the DNA they gave you, was corrupt, but based on hence the Solo cup. Wouldn't this been a time, Michael, though, that the photo that we've all seen of Mr. O'Keefe's arm with the scratches, the deep scratches, that's what we're alluding to, that somehow Chloe was a part of it, they would have brought that photo into evidence at this moment?
You'd need a foundation for the introduction of the evidence, and then the cross-examination on this witness would have been, you can't discount whether those are dog scratches or not. That's not her expertise. Her expertise is DNA. And as Sue pointed out, the problem with it was great from the prosecution standpoint, except there's an old adage, and I'll say it with my Boston accent, garbage in, garbage out. If this all red Solo cups and the manner in which the evidence was preserved, even finding the shirt on the ground after the first responders were there, you can't really necessarily trust that the samples were valid. If the samples aren't valid, then neither is the result.
And remember, we have a lot of problems with the state police lab, right? We've done lots of stories on that state police lab and problems that they've had. So if you have an informed jury and the defense is demeaning the way that the state police lab worked, if you know that, that's in there.
Well, then I feel like it makes almost all the physical evidence we might see in this case impeachable.
It is, and that's the problem, is that the manner in which all the evidence, well, mostly the evidence was collected, doesn't meet proper protocols.
But Michael, how do you successfully prosecute a murder case with impeachable physical evidence?
Well, there will be some physical evidence that will be less impeachable. As we've said from the outset, let's see what the toxicology reports say. Let's see what the blood draw at the hospital where she was treated says. And let's see what that's going to indicate. Then the next part of it is the analysis of the accident. The problem with that is we know that the car, there's allegations that the rear of the vehicle has been tinkered with. There's even some testimony already in the record that the police contributed to the breaking of that light. The problem on the recreation is it's also tainted and impeachable evidence in all likelihood as well.
The expert, though, did say that they were on the phone, spoke with the person who was collecting the data and walk them through, distilled water, let it dry, put it in here. And they kept reinforcing the package that arrived the way it was expected to arrive. It looked like it should look. So did that do enough to offset everything that you were just saying about questioning the credibility of the evidence that they sent?
Well, Jackson tried to get a question in impeaching the person who worked at the state lab, which got objected to and sustained, but the jury still heard it. And we have this visual of these red Solo cups.
You can't unsee it.
You can't unsee it. And you've got the tape. There was an issue about whether or not one of the Canton officers had ever used evidence tape. And then you got evidence tape right there at the DNA lab.
We have like 5 seconds. Did the jury look like they paid attention?
Yes,
sometimes
she did a
science
great
can
job.
make people fall asleep.
These are expert, and you can know better than I. They're good at speaking to juries. So except when we got into the different
And
tests.
juries look for the science now.
Right. Okay, I agree. Guys, thank you. All right, when we return, Michael Coyne will answer a few of your questions.
Stay with us. You're watching Canton Confidential.
Welcome back. Before we go tonight, we want to answer some of the questions we've received from you at home. This one is from Julia S. She says, quote, I am also watching the Chad Daybell trial in Idaho, in which the judge does not allow witnesses to watch the trial or talk to other witnesses. Is that the same in this case, Michael?
Yes. Generally, you move to exclude the witnesses from the courtroom so they can't listen to each other's testimony and conform their stories to what they've heard happen. So here, the witnesses can't be physically present, but we also don't want them watching TV. So again, for the same effect, you don't want them rehearsing their testimony and making it conform with other witnesses.
All right, we have another question here. This one looks ahead. It's an interesting question. Brooke M. wants to know, if the jury says not guilty, can Karen Read be charged again in a federal investigation? And would Read be entitled to money from court fees if she's acquitted?
She could be charged with the federal offense if, in fact, there were federal offenses here. We saw that in the Rodney King case in California, where there was an acquittal on the criminal charge for the police officers, and then they were charged federally with civil rights violations. I don't see where civil rights violations would land here, so I don't think you're likely to see that, and I don't see her be receiving court fees. The question is, was there enough evidence that they could bring the charges? The answer is yes. It's a long-term question whether they have enough evidence to actually get a conviction. But that still doesn't mean she gets compensated for her losses here.
What is the lowest thing she's charged with? We know the highest is the second degree.
Leaving the scene having caused injury or death. and being under the influence of alcohol. The charge that's most likely to land, if at all, is the vehicular manslaughter charge, which carries a 5-year sentence. But even the sentence of leaving the scene having caused the death or causing injury still carries with it a mandatory minimum sentence, but it's far less than the other charges.
Okay. Michael, thank you, as always. If you have a question for our experts, send us an email at canton.confidential@nbcuni.com, because we would love you to join the conversation. That's what this whole segment is about. We want to hear your questions.
Yeah, we read every single question that comes in. Tomorrow is expected to be a half day of trial. We'll have a full recap right here at 7. We'll see you then.